Welcome to today's episode of our most educative and informative talk show, Policy Pulse. Today, we are going to tackle a very pressing issue that affects countless of Ghanaians. It's about the rising cost of rent. With tenants facing long advance payments, frequent rent increases, and insecurity in their living conditions, as well as the frustrations that they encounter being confronted with rent issues, despite the protection outlined in the Rent Act of 1963 and the Rent Control Law of 1986. It bedevils my mind that these questions and the effectiveness of these regulations are always brought to the fore. The recent viral Rent Must Be Reduced campaign has brought this issue to the forefront, amplifying public outcry and the demanding. Let me take this portion again. Yeah, so I'm just doing the viral rent. This time, yeah. The recent viral Rent Must Be Reduced campaign has brought this issue to the forefront, amplifying public outcry and demanding action. Today, we will delve into the crucial gap between the law and practice, examining the effectiveness of rent regulation institutions and the potential for reforms, such as the pending rent bill, stricter enforcement measures, and innovative housing solutions to deliver genuine fairness in Ghana's rental market. Join us as we engage with experts and stakeholders to unpack these complex issues and explore what needs to be done to ensure safe, affordable housing for all Ghanaians. I'm your regular host, Cephas Na Dosu, and joining me to delve into this topic is the head of PR and senior rent officer of the Rent Control Department of Ghana, Mr. Emmanuel Hovi Bosu. Sir, you're welcome.
Thank you, sir.
Also, here with us is the Secretary General of the National Tenants Union of Ghana, Mr. Frederick Opoku. Sir, you are warmly welcome.
Thank you.
This program is solely sponsored by Hedge Pensions Trust. To start with you, sir, Mr. Posu, we hear about the Rent Control Department. Basically, what is it about? What are its functions? Can you walk us through that?
Thank you very much for the opportunity. And as you rightly said, we are here to educate the public. You know, the Rent Control Department was born out of the Rent Act, the Act 220, that is the 1963 Act. Another Section 5 of the Act, it has spelled out the functions of the department vis-a-vis the rent officer. So with your leave, just let me quote what Section 5 of the Act states. Section 5, subsection 1 states that subject to the other provisions in the Rent Act, the rent officer may discharge all or any of the following functions. I repeat, subject to other functions of this Act, the rent officer may discharge all or any of the following functions. A, may assess the recoverable rent of any premises, whether or not the premises are occupied, on an application made by any landlord, tenant, or person interested in the premises, after such inquire as he may think. B, shall investigate in such manner as he may think fit complaints by landlord against a tenant in respect of arrears of rent, and complaints by a landlord, tenant, or any person interested in the premises against any person in respect of any other matter mentioned in the Act, and shall make a determination thereon. C.
Mr. Pusu, let me come in a bit. Out of the institution, we have the employees who derive their functions from the law or the legal statutes that establish the institutions.
Exactly.
So I would wish that you focus on the functions of the rent control department, not the officer per se.
Yes.
Because the officer's duty is derivative of the department.
Yes, so the officer represents the department.
Okay.
So the functions or the action and inaction of an officer will affect the department.
All right.
So as I'm speaking now, the functions stated under Section 5 is the functions of the department. But the person who has to lead is the officer. So the officer is performing the functions that has been spelled out in the law. That has to be done by the department.
Thank you very much. Let me come to Mr. Opoku. You are the Secretary General of the National Tenants Union of Ghana.
Right.
Basically, what is that union about? What brought it into being?
Very well. Let me say a very big thank you to Clock TV and for inviting us to this very important platform. To begin with, I would say that the National Tenants Union of Ghana has been in existence for the past decade. And we believe that housing is a very big issue and that there's a need for people to rally together at a common place to make sure they are able to, as it were, advocate for the rights of the people and to ensure that policymakers will walk the talk and act in accordance in respect of the dictates of the Rent Act. So first, three things brought us into being. We educate, we inform, and we influence. When you say we educate, we have a responsibility to educate our co-tenants about what the law says, the do's and the don'ts of the landlords, the obligations, rights, and responsibilities of parties, in this case, landlord and tenants. What are your rights? What are your obligations under the law? So that landlord and tenant can live in harmony and in peace. Number two, we inform. This has to do with giving opportunity for people to call us and take advice in respect of the law, or if they have any encounter with their landlord, how do they settle it in respect of the law? We give them information from that angle. And lastly, we influence policy direction. We believe that whatever we do, the government and for that matter, policymakers are responsible for ensuring that, yes, they're able to bring policies and level policies that will inform and change the lives of many. Unfortunately, it's like many years after Nkrumah's regime, since 1963 to today, 60 years plus, we are where we are. What was the reason why the 1963 Act came into being? Have we achieved it? Or we are getting closer? Or we are far from achieving it? Because what we experience now, millions, I would always say that we don't have no less than 11 million Ghanaians who are tenants and so forth.
Thank you, Mr. Opoku. I think you are going a
Jumping.
bit fast.
Okay.
Yeah. Because basically, I wanted to know how it comes, the decision came to be. So who constitutes a member? How do you become a member?
It is a free zone association. Anyone who is a tenant, if you rent, whether commercial or residential, if you talk about tenants, the same law regulates the activities of people who give rent, their premises for commercial activities. Therefore, if you are wherever, whether you for shop or store or your office, you are still a tenant. And the same law regulates all of us. So anyone who rents and pay for rent.
So does it mean that once you are a tenant, you become automatic member?
Exactly, you.
Without going through any registration procedures or processes?
We have a database of about 200,000 registered members. Mm-hmm. And as I said, we have about 11 million tenants.
You know, I'm coming.
Yes.
You see, the Constitution of Ghana
yes.
grants the citizenry
yes.
the freedom of association.
Exactly.
So association is not by virtue of the fact that you fall into a particular category or class. You must go through some process of you committing yourself to the association. So if you say once you're a tenant, you're a member, it's a bit...
the truth is that we do advocacy. The essence of the membership is not to do anything, but it's to ensure that we can influence policy. And if indeed I sit on this platform, I say anything, I meet any government official, you may not be a member directly, but if the advocacy can transform your life, you have been impacted. Therefore, on the lines of advocacy, we have the belief that anybody who is renting, that out of our advocacy,
benefits,
you can improve your life.
Has become a member.
Because we don't take you dues. We don't take you any money to be part of it. Ours is to ensure that you can understand the law. If you have a difficulty, we can explain to you.
How do you fund your programs?
Individually, we are passionate about what we do.
Okay.
And ever since we started, we have never approached any individual. But anybody who, for me as a member, who's a founding member of the group, we put ourselves together. For us, I'm coming here. I'll just have to find my resources and come because it's out of passion. Because we do not want any government, any policy people to influence what you do.
So do you have an executive or association?
Yes, we met His Excellency President Mahama.
Is it registered?
2017 at the Registrar General Department. So this is a formal organization, not just about advocating because we want to advocate. We are constituted, we have members, non-members and members. Here in this case, general members and people who think that, okay, if they have an issue, we can solidarize with them. If we're going to rent control, for example, and we believe that we can follow you as to sympathize with you, we can go and listen and be part of it.
So for instance, if I'm a tenant,
yes,
and I have rent issues with my landlord,
yes, how
do I assess your support? And what kind of support can I assess from you?
First of all, we have an office at Oblogo, Weja, right? And we run like now everything's online. You call us 24/7. It doesn't matter where you are, which region you are. So long and so far as you have an issue, put a call through 24/7, and we are with you.
And what would you do?
First of all, we say if you want any advice, or you have an issue with a landlord that you are not too comfortable with, have you breached the law? Is the landlord taking advantage over you, or what? We try to explain to you and place you at a point whereby you will feel like at least you are getting something out of the organization. After just giving you the information alone is something worthy that we think that we are doing a lot. And the solidarity, we give it to the general people. For example, if somebody has been evicted from a premises, right, and it is not justifiable, in fact, going to the extent of getting the legal representation, not even rent control, if we choose to do that, getting a pro bono people, facilitating and connecting with the legal luminaries who believe they can donate some of this thing for pro bono. We go to the court of law.
So how are you assessed?
In so many ways. As I said, one, You can access us online. You can come to the office, and that we give you 24/7 all the time. It doesn't matter where you belong because we don't have the resources to establish
Do you
ourselves
have
across the
any
country.
contact number?
We do.
What is it?
We have 0244 633 447. Then our hotline that you can reach us on is 0303 960 792. That one, if you call on the landline anytime 24/7, midnight, we don't close because we run 24/7.
So let's assume that today I'm a tenant.
Yes.
And so automatically, by your definition, I'm a member.
Yes.
Tomorrow I become a landlord. Have I lost my membership?
You haven't. You see, we try to. We are not, because without landlords, tenant cannot survive.
So is it tenant association or tenant landlords
It
association?
is tenant, but we don't antagonize landlords, because I should be able to let you know the responsibility of the landlord. Or if you're a landlord that you have an issue, you don't understand something about the law, or you don't have to managing your property, or you have difficult tenants, there's nothing wrong coming to or calling tenant union for an advice, because the law is landlord tenants. Therefore, we cannot room and always consider or take only the tenant, and that if we are against landlord, that's not right. And that's
interesting.
right, yes.
We'll come there. So Mr. Kwasu, how do you regulate, what do you call it, rent in Ghana? How are you able to regulate it? I know you've quoted laws, what have you, but somebody will say that, yes, the laws are there, but how do you practicalize it?
Okay, so just as I was reading, the act came with an ally.
Okay.
Okay, so the law has given us a guideline as to whatever issue, what you have to use to administer or to educate that. So the regulations guides us in managing landlords, tenants, and anybody who is interested in any property. So basically, that's what you do.
You see, because I'm looking at the vastness of the country,
Yeah.
and even within Accra, the spread of rentable properties.
Yes.
And how you are able to navigate through these to be able to regulate. For instance, if I'm renting an apartment somewhere, do I need to come to you before I engage the landlord, or I can go ahead and unless there's a problem before I engage you? Okay. And how do you ensure that I am being given fair charges as far as the rental property is concerned?
Okay, so just as I mentioned, we are guided by the laws and the regulation. Under Section 4 of the Rent Control Law, mandates every landlord to register what we call the tenancy agreement before collecting money as in rent advance. What the process is that if you are a tenant...
I want you to restate that point again. That
okay.
Before the landlord decides to let off his rentable apartment, the rent agreement must first be registered, not the apartment.
Okay. So what you just have to, let me repeat that. If you are a tenant and you are interested in any property, after doing your due diligence and you came to a realization that I want to accept these premises and reside in it, the first thing the landlord must give you after showing interest is the tenancy agreement, because that will spell out your rights and responsibilities as well as the landlord's rights and responsibilities. So you first have to get hold of the tenancy agreement, read and understand, and sign. After signing, the landlord is required under Section 4 of the Rent Control Law to register this tenancy agreement with the Rent Control Department. If it is approved, the landlord then will go back and collect what we call the rent advance. Okay, so this is where we come in.
How is the approval communicated?
The communication is...
And so it is the landlord who has to submit
exactly.
the
tenancy agreement.
Tenancy agreement.
Yes.
to your office.
Yes.
So how do you communicate that approval?
Yes, so we communicate, normally whether soft copy or hard copy, when you bring or submit it in terms of registration, we go through and make sure that you are not going to infringe on somebody's human rights. We make sure that the approved rent advance that you are supposed to collect is stated there. Your rights and responsibilities, as well as the tenant's rights and responsibilities, form within our laws. If we check and all this out, we give you the go-ahead and go and collect what we call the rent advance. So the communication
the
is done.
ahead is what I want, because you
Yes.
see, eventually, this tenancy agreement is going to be executed between the landlord and the tenant.
Yes.
It is the landlord who has come to your office submitting a draft copy of the tenancy agreement.
It's signed.
This-
Yeah.
Signed by him.
By him and the tenant.
No, but the
and
point is
those
that-
witnesses.
No, let me agree.
Yeah.
Let's take it easy.
Yes, yes.
Because the point is that you said before he goes to collect
Yes.
rent advance,
Yes.
the rent agreement, tenancy agreement, must be approved.
Yes.
So if it has not been approved, why do you get the parties signing on to an agreement that hasn't been approved?
Okay. So the issue is that when you go before the landlord, he has to issue with the tenancy agreement. You, with whatever you are requiring to do or requesting for, if it's there, the two of you will sign. The landlord will register the signed tenancy agreement, which means the parties have agreed. We come in to do some checks to make sure that what the two of you have signed form within the confines of our laws. If there are any...
Has there been an issue or an occasion where a signed tenancy agreement has come before you and your office has rejected it based on unfavorable conditions stated therein?
Okay, so there are instances which has occurred. What we do at that instant is to advise the landlord to go and amend those clauses and resubmit it to the tenant, and then they put their signatories before it, before the landlord is required to collect what we call the rent advance.
Okay, so I'm sure the principal reason for the establishment of the rent control department is to protect the interests of the parties when it comes to a rental, what do you call it?
Exactly. Exactly.
And so, at what point would the tenant be convinced? Because sometimes at the point that you're looking for an apartment to rent or a place to rent, there's desperation.
Exactly.
And so, out of desperation, some people can cash in.
Yeah.
And so, if at that point the rent or tenancy agreement has not been approved and there's no way of verification by the tenant, don't you think that the landlords can still cash in on them?
No,
and if they can, how can we prevent that?
Okay. So at the end of the day, you, the tenant, must do due diligence. Okay. Of course, we keep on advising tenants that if you don't have the know-how to interpret some clauses, you can contract any lawyer to assist you, or you can as well come to the rent control department for us to advise you before you put your signature under it. Okay, so this is the advocacy or the sensitization we are doing. Just as you are saying, when you come before us as a landlord with the signed tenancy agreement, and there are things that has to be amended, at the end of the day, you, the tenant, will have a copy. We have a copy of the tenancy agreement. So that's where, if you have any challenges, you bring it as a tenant. So our doors are open for both landlords. Just as you said, we are there to protect both landlords and tenants. So you, the tenant, if there's something that is itching your mind, you have the right to come before us.
Okay, Mr. Booker, I'll come to you. But before then, what ingredients do you look out for in a standard tenancy agreement?
Okay. So first of all, because it's an agreement between two parties, the information or details of the landlord must be there. That of the tenant must be there. just as I've mentioned again, your rights and responsibilities as a tenant and that of the landlord must also be there. The rent advance that you are being charged must be stated there. The way you will be paying must be there. The commencement date of your tenancy and the end date must be there. You should have witnesses because it's an agreement. You should have witnesses. So basically, these are the ingredients that are basic that must be in the tenancy agreement. We understand that tenancy agreement may vary from property to property. At the end of the day, the two of you must agree on what must be included. For instance, at the end of your tenancy, would the landlord give me a period to go and look for a place if I don't want to? Or when I decide that no, I don't want to occupy the premises again, how many months or days do I need to give the landlord as a way of notice? Under Section 17, the landlord also has right to recover possession. If it comes to his mind that I want to recover possession, how many days or months will the landlord is required to give me? All this must be stated in the tenancy agreement. It's not part of our laws because it's not stated in the act. But this is an agreement between the two of you. So the two of you must agree that when I want to move out, how many days or months do I need to give the landlord? Or if the landlord wants to recover possession, how many days or months notice does he need to give me? So these are outside what the basic tenancy agreement is. And there can be numerous tenancy inclusions in the tenancy agreement. And it varies from property to property. Yeah.
Mr. Puku,
Yes, sir.
representing the interest of tenants, I want us to look at, again, the tenancy agreement. Because for most often when someone is looking for a place to rent, there's desperation.
Yes.
And so would not have the time of going through all these due diligence, making sure that the tenancy agreement have been drafted. Sometimes they even move in before these things. What do you have to say about this tenancy agreement and the procedure, the process of getting it approved or sanctioned by the rent control department
Thank you
before
very much.
execution?
Before I come to that, I was listening to Mr. Posu, and if you permit me, I would like to say one or two things in respect of some of the presentations points. First of all, I have actually met Mr. Posu many occasions, many years, and he's doing very well because the burden on him to prove what he cannot be proved is very severe. It's unfortunate. Why do I say so? Look, I have described, or the Ghana Tenant Union have described rent control as an institution that indeed is not living up to expectation. Unfortunate. That
Well,
always make that.
I think that
Yes.
let's be mindful with our pronouncement.
Okay.
There is no institution that is perfect. And one of the things we're trying to do is, as far as this program is concerned, is look at the gaps and prescribe solutions. And so if you saying they have challenges, but I want us to look at first the process where there's tenancy agreement signed, witnessed, before it goes to the rent control for approval. I mean, what do you have to say about this process?
If I want to, let me go back. I still have a point to make, and I don't want to move on without making a critical point. I insist. What I'm saying is, I'm coming. Sorry, I'm not going back to what I want to.
We are not in a banter.
I understand.
So when you preface your statement,
Yes.
by you insist, I'm in charge here.
Okay.
So you don't insist.
I retract.
Okay, thank you.
So what I'm trying to say is that you made mention that because there's pressure in the system, when somebody is securing a place to live, there's no time to be waiting for certain things. And out of that, the landlord has an upper hand many a time over the tenants. And for some time, if you put 10 tenants and landlords there, not even maybe 3 or 4 would want to give tenancy agreement in the first place. Now, you asked questions about people registering their
Tenancy agreement
with their rent control. I'm not working with them, so I don't want to go there as well. But it is very evident from the information we've been receiving all the time of landlords who even hesitate not to give tenancy agreement to their tenant. But when they go to the rent control, when there's an issue, first of all, basically, the rent control should even ask, have you given tenancy agreement first? Number one. That's one. Now, if the person has not, it's more or less a breach. And that he who seeks equity
must come with clean hands.
So if your hand is dirty, though you want to resolve an issue, and one party has even erred, in law, you must, though you give them equal hearing. But the point is that...
what I wanted is your opinion about the process. You see,
Mm-hmm.
we are looking at ways of improving the policy direction to address issues on the ground.
Yes.
Mr. Kposo has told us the process.
Yes.
That the landlord and the tenant first enters into agreement.
Yes.
And this agreement is what must be registered, what is registered. And I'm asking your opinion about this process, whereby the agreement is concluded, is sealed, before it appears before the rent control. If they find something untoward about the agreement, there is which is not in the favor of the landlord, there's a likelihood that he may not go back to get it reviewed. And so ask somebody representing the tenant association, what is your opinion? Do you think that this process is okay for you and your members?
For me, if I want to make comment on that, I would say that it is not.
Okay.
Okay. Because the difficulty or the pressure on the people before, even because of, does not give them fair grounds to make proper input.
Ensure adherence.
That one alone will not make it fair.
So, Mr. Kposo, how do you ensure compliance as far as this practice is concerned? Because, like I'm saying, at the point that you're looking for a place to live, you are desperate.
Yeah, so the issue is that, you see, rental in the country is a problem.
Okay.
It's a problem in the sense that we have a huge housing deficit. So one property, there are about 10 people fighting for the same property. But what we are sensitizing a tenant, despite the pressure, despite the eagerness to get a property which is closer to your children's school, your church, your workplace, we've been advising them to do, first, due diligence. Second, to demand what we call this tenancy agreement. They shouldn't be so desperate to be paying money to landlord without getting hold of this tenancy agreement. Because at the end of the day, your rights and responsibilities are stated in that. The landlord rights and responsibilities are also stated in that. So if you demand it 1 or 2 times and the landlord is not willing to give you, just as our doors are open, you have the right as tenant to come and inform us so that we'll drag the landlord.
Will be ejected.
No, the issue is that you've gone to request secure the place.
Okay.
You've requested for tenancy agreement. It's not forthcoming. You can report to us. Our office is to reconcile and promote peace. At the end of the day, under Section 17 and Section 25, which talks about recoverable rent and offenses, nothing is stated in there that when you are demanding something and you report to the landlord will stand on that to evict you. So if it comes to that, we insist that the tenancy that you've signed
must
persist. Okay? So we are just educating the tenant that you should demand those tenancy agreements. And just as we mentioned, how do we enforce that? We enforce it in the sense that when there's a dispute, the first thing we require from the parties is what agreement do you have between yourselves. In most cases, the landlord is eager to evict a tenant because of non-payment of rent. So at that moment, we know there is going to be a divorce between the two parties. So demanding a tenancy agreement with somebody who is about to move out would not be right. So we ignore it. And we advise the landlord that your next tenant, you should make sure that the tenancy agreement is improved. There's been instances where tenant has come into our office who has demanded tenancy agreement. We've dragged the landlords and we've insisted because most of them don't know how to do it. In that case, we advise them to see a lawyer to advise them, or we have samples of these tenancy agreements. We willingly give it to them to go and insert whatever will suit the two of them and issue to the landlord. So this is how we are ensuring that those tenancy agreements are issued to tenants.
So a quick one.
Yeah.
How do you mediate and misunderstandings or conflict between tenants and landlords to the extent that it does not escalate into what do you call it, especially when the landlord and tenants are living in the same property, there's disharmony. Then also is the fact that assuming that there's conflict and the issue comes before you and the one, either there are no tenancy agreements or two, there is a tenancy agreement which is not registered with you. What are the ramifications?
Okay. So in the first place, if there's no tenancy agreement and the contract has not ended, the tenancy has unended, we insist and make sure the landlord issue the tenancy agreement to occupy the period that has. Exactly. So that's what we do first. And as I mentioned, our motto is to reconcile and promote peace. So the issue about any conflict between landlords and tenants, of which the tenancy has not ended, we use our expertise to make sure that at the end of the resolution, they will go and live in harmony until the tenant decides to move out or the tenancy ends and the landlord does not want to renew it again. So based on our expertise and based on the regulations that we put before us, we make sure that they go and then live in harmony.
Yeah. So we realize that in even football competition, I mean in games, you always have a neutral person who serves as the referee or the umpire.
Yes.
So in a relationship of tenancy relationship between a landlord and a tenant, you definitely would need an independent person to, arbitrate issues because there are bound to be issues here and there. Don't you think that the office of the Rent Control Department is relevant? And for that matter, we should not be running it down, but rather looking at ways to make it fulfill its mandate?
Look, let me be very frank, sir. The law is the law. If you are mandating an act to make sure the law works, you don't have any excuses. And that law is supreme than anything that the subsidiary. We have a rent law that tells you as an officer to do A, B, or Z. You don't have any reason to come and give any excuse. If any issue go to rent magistrate, and the judge sits on the case, he used the law and does not look at whatever you did or whatever you didn't do. Or if based on maybe some inefficiencies or some deep challenges, you are not able to do as expected. In the eyes of the law, you don't go there and give any excuses over there. What we are saying is that rent control as an institution is mandated and bound by the Rent Act to do A, B, or C. For example, I'm not working with them. Even if you come to the registering of the tenancy agreement, it is very fundamental by Section 4, as indicated. I didn't say it, that it must be registered. So if a landlord comes to rent control with an issue, fundamentally, evidence rule, did the landlord do what must be done? If he didn't do we entertain the landlord at all? Whether you are reconciling or whatever, yes, you are reconciling with your motto. It's good. However, we have to look at the context of the law and the position of the law not whatever your motto tells you to do. Therefore, you may be magnanimous at times and be so in a way to resolve matter because it's about one-on-one. This is not about court matter. So you have to use certain exploits to ensure that there's peace. So sometimes you may be calm working outside the law to fix an issue. But if the matter goes to the rent magistrate is bound by the law to apply the rules of the game. So all what I'm saying is that, yes, rent control is doing so much. I know they are a-resourced, I'm aware. And that has been one of the biggest challenge on the part of rent control. So wherever platform we have been as rent tenant union, the rent control ability to stand firm will be the success of tenants and landlord alike. Therefore, I have never stand on any platform to run anybody down. But I speak on the position of the law. And when it comes to the law, it's not about running somebody down or bringing somebody up. It's about, are you working in tandem with the law or you are not able to apply? Therefore, if you are not able to apply the law as it must be applied, then you will be described, if not carefully taken, as an entity that is not living up to the expectation. And if you have a mandate and you are not living to that mandate, you can be tagged also as an entity that is not doing anything and that you become irrelevant, based on the fact that you are not able to implement the law and what the law says. In the law, you see me. So rent control also say, okay, because it's me, because it's not sha and it's me, we believe that we are handicapped because of the me. And the me is making them very inefficient. And that's all what I'm saying. But I have never, and we will never say that they are irrelevant, or we will not even speak that rent control being there is no good, because I always go there when I have an issue. I also take people over there, I lead them and direct them. I don't sit on issue. Go to rent control because I respect rent control system. If not, I don't make referrals.
Thank you very much. So at least we accept the fact that they are very relevant and we must support them to perform the legal functions that have been ascribed to them, right?
The law and the policy makers should support them. Yeah. Me, of course, yes, of course.
Including all of us.
How?
Through advocacy. You do advocacy, isn't it?
But to a level.
No, so what I'm saying is that
for 10 years.
I'm coming. You do advocacy.
We do.
And so if you have said that the authorities or the consumer bodies that have been set up to support them must support them.
Yes.
Through your advocacy, they can hear you to support them because you said they are under-resourced, isn't it?
Yes.
But fine. But then, Mr. Kosu, sometimes it appears as if when it comes to rent issues, it is only landlords who are always, fall at the side of the law. And that tenants are always right, landlords are always the ones who are problematic. What are some of the issues that come before you from landlords?
Okay, so one which is trending is the inability of landlords to pay their rent.
Landlords or tenants?
Tenants who are unable to pay their rent, yes. The Rent Act stipulates that you, the tenant, has no right to owe any landlord more than a month's rent. Okay? And because of the economic situation, we see a lot of tenants who are unable to pay their rent. And because most landlords also depend on the rent to survive, any 1 or 2 months default will push them to the rent control department or the magistrate, because they cannot take the law into their own hands. And that's just as I've mentioned, we work in tandem with the magistrate. So at a point when we reach a point that there should be an enforcement of punishment or any fine, we don't have that mandate. We have to push it to the magistrate. So just as I mentioned, the key on our list is inability of tenants to pay their rent. What is also trending is inability of landlords to refund rent advance to tenants. In a situation where a tenant has paid so much rent advance to you, and there's a need for the tenant to move on from your premises, of course, the period of which the tenant has not used the premises and he has paid for rent must be refunded. But because most landlords even spend those monies before even the rent is paid, it becomes very difficult for them to refund those rent advance. And the notion most of them have is that wait till somebody come and occupy the place before I refund your money to you. But those instances are very peculiar because most tenants also pay money for the renovation of the place even before they go in to rent it. So at that point, you realize that the landlords will not even take 1 Ghana cedis to pay for his child's school fees. All the money you've paid has been invested in the property. So when it comes to that instances, we have to weigh into how we can resolve that issue. Whether we have to insist that because the money has been invested in the property, you have to give the landlord some few period for him to get somebody to exactly before. But in the instances where you've made your building perfect and somebody has paid money and you've invested the money in somewhere, we insist that you go and take the investment and refund the money to the tenant for the tenant to move on. Also on the list is what we call inducement. Inducement is when the period for the occupancy has not reached, but the landlord has started doing things that will push the tenants away so that in the minds of them, they can get somebody to come and occupy. Most of them, during our investigation, also shows that because they took so much money from a tenant, and now somebody has promised him a higher rent, it will start inducing you, doing things that you say, if you can't, move out. And then that they will get the advantage and then move you out, get the money from the new tenant who is coming to pay so much for him to refund your money to you. So these are some of the key issues that we've been receiving in our offices.
That's wonderful. But I want us to look at the Rent Act that caps advance to 6 months.
Okay.
In the first place, it beats my imagination that we are in the free market economy. You know, if someone goes to buy his tomato and is selling, government does not dictate the price. Even in the past regime, there was an effort to put a cap on the price of cement. It didn't succeed. Why are you putting a cap on how much and how many months rent I can take when at the time I was buying my cement and building materials and going through the frustrations, you did not contribute to it? Why should government take that stand?
Okay, so just as the notion or the aim of the act is to protect both landlords and tenants, okay? It's true that when you were buying your iron rods and cement or even sand and stone, rent control was not there, or even the government was not there. But we need to protect the vulnerable. Protecting the vulnerable, we are not saying you shouldn't take rent advance. The law has capped it to a certain level so that you can go to that maximum. But just to mention, this is done under Section 25 of the Act, of which it has spelled out the kinds of tenancy. We have short tenancy and long tenancy. The short tenancies are tenancies that does not go beyond 6 months. And the law is requiring that because of the vulnerability of the tenant, you shouldn't take more than 2 months rent advance from that tenant. Okay? And when it comes to long tenancy, which spells out or spans more than 6 months, which can go beyond 1 year, 2 years and above, the law, what it's saying is that you should not demand more than 6 months rent advance. Because the law recognizes that building or the housing industry is a long-term investment. So if it's a long-term investment, you cannot use 1 day or just a few years to recover your expenses. It's a long-term investment. So the law has stated that you should not demand more than 6 months rent advance. But of course, the underlying where there is demand, if you get a tenant who is willing to pay 1 year, the law does not forbid you from collecting. And the law does not forbid the tenant from paying. This is a gap that we've seen in the law because a lot of landlords are bypassing this and then doing things that will, because at the end of the day...
So in the agreement, it is couched that the tenant has agreed to pay and the landlord has agreed to accept.
Okay, but if it's capped, that whether you collect or you demand, you flout the law, then that will put some sanity in the industry. So in the review of the law, what we are currently doing, and looking at the interests of both landlords and tenants, we want to cap it to 1 year. That 1 year, we want to state in there that when you demand or you collect more than the 1 year rent advance, then you flout the law. And of course, this one, you have no excuse. Whether it's the tenant who gave you to you, offered to pay you, or you demanded it, the two of you have jumped the gun. So if there's any punishment, it will go to the two of you. But until we amend the law now, we will still have that situation. Because at the end of the day, if there's no evidence that it's the landlord who demanded more than the 6 months rent advance, it will be very difficult for us to put you before the magistrate or the judge for any punishment that has been spelled out in the act to be meted on you. So until we amend the law to cap it that whether you demand or you receive, you go against the law, we will still have this situation. But when you see the tenancy agreement, just as you said, it is stated that the tenant has paid 2 years. Was it a case that the landlord demanded the 2 years, or is the tenant who offered to pay the 2 years? That will be a challenge. And we cannot go before the magistrate and verbally go and state that the landlord has taken 2 years rent advance. What is the evidence that the landlord demanded more than the 2 years advance? So we are working on the amendment of the law so that all of us will be abreast with that.
It's good in your presentation you mentioned the pending rent bill that is under consideration. I don't know which stage it's got into. But Mr. Poko, I wanted to find out whether in crafting the new rent bill, whether your association was consulted, and if they did, what propositions did you make for inclusion?
Okay, very well. Thank you. I think once a while, when, for example, when they were about to make an input into that bill, we received a letter from the ministry to also come out with a paper, like put our position and that, which we also, forwarded. Maybe I can say that we represent the voice of the tenants, and that whatever we put in, more or less, is representing the people that we say we represent. And when I saw the bill,
draft,
there's nothing that we said that was there. And when they are having their meetings, no engagement. Like, fine, you brought it. You feel like we want to put in, we put in. It's not easy, we take it out. So getting a round table to get the stakeholders. And for me, if you're doing a law for me, it is important that the tiers of class, the classes, the ministry side, the other stakeholders all come at the round table. It's about taking ideas, making an input. Maybe if you give me the chance to make a presentation, maybe direct from me, or I can also hear somebody's, and also maybe support or oppose in that distance. It will find, but unfortunately, that's not what we see. So I wouldn't say we are not part. That will not be fair, because so far as they give you a letter that brings something, though they did it, they threw it somewhere, or some other ideas came.
Okay, but
that was better than.
Honestly, it's not only about your views being sought, but I wanted to ask. I was asking you, what were some of the propositions you made to be considered in the new bill?
For me, we were thinking that if we look at the landlord, and as Mr. Pusu rightly mentioned, that point of it should have been clearly stated in the law that if you take this amount of money, or maybe more than 6 months, this is how the law should be done.
Deal with you. So the penalty section,
which is not there. And also rent control today, when there's an issue, they are limited in their powers. And that rent control is like, let's solve the problem, the issue. After we are done, we can't enforce it. They cannot, because it must be enforced by the rent magistrate. So if the other party disagrees that yes, we are settled, but the rent control does not have that powers to enforce their own
Is the procedure true? You don't have prosecutorial powers?
No, we do have prosecutorial powers, okay, just like the police, but we need to seek leave from the Ministry of Justice and Attorney General, which we've not done. So currently, we cannot prosecute anybody before the magistrate because we've not gotten that leave. The issue
okay,
about...
But then, if you can also touch on some of the proposed amendments, apart from the rent advance thing.
Yes. So, and including what my good friend just said, you know, at the end of the day, the law will list all the sections, and then at a particular section, it will list the punishment that has to be effected on those things. So it was in the bill. Unfortunately, the bill was not able to be passed during the last administration. So we have to kickstart the stakeholders' engagement again, which we've not done. So definitely we'll involve the stakeholders again. And one key issue in the amendment is just I've just mentioned. We want to cap it to 1 year because a lot of landlords are crying for the long period, not just the long period, but the super long period they will use to recoup their investment. So that is one. The second issue is that there have been a lot of cries about government imposing how much landlords should take as far as rent is concerned. So what we've put in there, which we will expose it, is to set up what we call independent assessment committees. The people to be involved will be the tenant union, the landlords association, if there's any professionals like lawyers, valuers, and others. So every district will have an independent assessment committee, excluding the government vis-a-vis the rent control department, so that it will be their baby. At the end of the day, when there's the need for them to do an assessment, all these stakeholders will go and perform that assessment, and they will come out with the rent. When they come out with the rent, we know that there has been an involvement of a tenant. There has been an involvement of a landlord. There has been an involvement of a valuer, so that it will not be that government is imposing rent on you. Because what they have to look or they factor in is where the land is, where the property is sited, what materials have been used, how much property rate do you pay. So all these factors will be in there to determine the rent, so that you, the tenant, will not say that it's government who is imposing rent on you, or you, the landlord, will say that, no, I've built my property when I was buying my cement and this thing, you were not there. So why are you determining the rent? You'll be involved in determining the rent. Again, when we get to our schools, based on the hostels, we know that the tourism ministry is involved in registering and licensing them. But when it comes to how much they should charge the students, as far as the hostel fees are concerned, there's no regulation. So when it comes to that place, the student union will be involved, the property owners or the hostels managers will be involved. Even the schools administrations will be involved. And again, valuers, lawyers, and those who will be involved. So that at the end of the day, when that fees, the hostel fees is determined, we know that the hostel managers have been involved, the students have been involved, and all those who matters around that vicinity would have been involved. So these are some of the key issues. And again, people have cried that the rent control department is so intimidating. The name itself is intimidating. So there's been a lot of, of the control. So there's been a lot of proposal as to the change of the name. I mentioned somewhere that we are coming up with a very romantic name that everybody will accept. So these are three key issues that we are inputting in the act so that everybody will accept whatever will come out.
Thank you very much. We'll go on a short break, but when we come back, we'll look at whether this independent body of valuers would not add up to heightening the cost of rent because they must be paid.
Exactly.
So stay tuned. We'll be back shortly. Well, welcome back. It's getting very interesting with the intended review of the Rent Control Act or the Rent Bill. I want to find out whether the inclusion or the proposed inclusion of the Independent Board of Survey or Valuers, wouldn't it rather tend to add additional costs to the rent charges and by extension making it more unbearable for tenants? So, Mr. Post, what do you have to say about that?
So the key issue is that it's the government responsibility to come out with affordable housing and then social housing for the citizenry, or even build more properties or more accommodation and rent them out. But because of the housing deficit, we need to do things that will make the tenant very, not so much burden on them. So the independent assessment committees is the government baby that has to finance it. But we shouldn't look off of the side that there are lawyers who are doing pro bono, okay? So if we get a valuer or a lawyer within the district who is willing to offer that pro bono services to the committee, it's welcome. But that's not the focus. At the end of the day, currently what we do is that when an officer, rent officer, perform an assessment, the fees and charges demands that the person, the landlord, has to pay 1 month rent advance of how much has been determined. So if an assessment is done and it's determined that the rent on that property must be 500 Ghana cedis, the one who applied must pay that 500 Ghana cedis to the government. So we'll look at if this assessment committee, this independent assessment committee, will maintain this. We'll ask ourselves, if it's even 1,000 Ghana cedis that have been determined, can he pay it for the people or the resource person that has been involved? One of the process that we are also asking is that they will not be sitting on one cases. At the end of the day, they will combine about the number of cases that will come within a month
to reduce the cost.
The cost. But how they will be financed has not been decided yet. But we see that the independent assessment committee is very key and is very important. So when the law is passed, how they will be financed will be determined through the regulations. So as we speak now, we've not determined how they will be financed. But some of the options are to get people who can voluntarily come on board to make sure they assess that the tenant will be satisfied, the landlord will also be satisfied.
So, Mr. Busu, this independent assessors, obviously they would, even if they are doing pro bono, they would definitely incur costs because they might need to move from one central location to a location where the property is located. That involves maybe transportation, time, risks, and what have you. And so, from the tenant perspective, how do you see this as an ill or a cure?
It's a cure. It's a cure because for me and for the tenant union, we believe that anything that has to do with bringing people to the table and getting ideas so that we all agree, so that tomorrow, as you really mentioned, nobody go back to say, okay, I wasn't part, I'm not aware. I'm not aware. I'm not aware. And that if I'm not aware, and maybe I stand on any platform say I'm not aware, then it might even affect the work of the committee. So if indeed there's going to be a committee of that, which I'm not aware, honestly, this is my first time of hearing him say this, which is that if that is the case, is 100% okay. But for me, definitely, when the law comes, definitely the government will find ways and means to make sure that, as was rightly mentioned, there's no way it's a pro bono. Because people move, how do I go and do assessment? And I know already they have some resources challenge. I know that if their law is amended or the act is reviewed, then it means that I know they are, according to their bill, rent management department, what they propose when they went to parliament all that time, it means that they are going to manage. So if anything that is management, there must be resources attached to do the management. Or you can never do anything, you say we don't have resources and what not. So definitely, we need the thing to be amended. And if this committee comes to fruition, for us, I think is the best. And we will find ways. I mean, if some of us have to even do pro bono because of the success of the project, because it's not about our benefit, it's about making and perfecting the system, and that we will be 100% be in support of that. So for me, it's a clarion call that if indeed we get to know the people is brought out, then we are aware that there's a committee of that sort, as Mr. Posu has mentioned, because he is very close to the system. And that I wouldn't doubt whatever he says here. But if that's the case, the 100% endorsement we think is good. And government should find ways and start thinking about it. Or those who go to the round table should begin to think and interrogate issues that we cannot bring these things if you want it to be effective without resourcing. And definitely, I think if they all think like that and make it and give resources, then people can also volunteer happily.
Okay. But one other critical intentions of or considerations of the new bill is to extend the cap on the rent advance payable from 6 months to 1 year. Do you see this as a way of creating some flexibility for landlords, or it's a risk that is what you call looming to worsen the plight of tenants?
My answer to this is two-way affair. It helps the landlord, it helps the tenant. Why do I say so? It helps the landlord from the angle that, okay, the 6 months cap, okay, I've invested in this property and I have to now, recoup my money. Therefore, if 1 year is given to you, it makes you also plan. It helps you to plan that every year, then I'm getting A, B, or C. And to the tenants, it makes it more predictable. Predictable in the sense that I know that the 1 year is what I'm going for. And that if I know landlord do not come and ask me pay 2 years, and that will give me a peace of mind. For me, now, it's not about how many houses you are building, but it's about putting measures to ensure that the legal framework is put in shape so that it can regulate the system and perfect the system. So for me, it is good that we will be seeing all these things coming up. And that's, for us, we also do intensify our advocacy to ensure that many people will be informed. Then landlords will also see the importance, how it will actually improve the lives of other people who are vulnerable. Though they want to recoup their money, then it will be win-win, not win-lose, so that we can all laugh and harmony. will be built.
Mr. Pusu, do you really see a win-win situation in this, where even the 6 months cap, it was difficult to enforce it, and now that you're thinking about 1 year, what's the guarantee that, if from 6 months, landlords can charge and collect about 2 years rent advance, then 1 year, they may be now ending up collecting about 3 years advance. How do you see the practicality in enforcing this as against the inability to enforce the 6 months cap?
Okay. So as currently, nothing stops the tenant from paying more than 6 months.
Yep.
But the bill that we are proposing, of which will come out very soon, it will be an offense for you, the tenant, to pay more than 1 year. So that will motivate you to make sure the landlord does not collect more than the 2 years. Okay, because at the end of the day, whether it's the landlord who demanded or collected 2 years, for instance, then the two of you will be against the law.
How would you know?
At the end of the day, you, the tenant, and again, lack of what we are saying, I always make this scenario that implementation of the law is a collective responsibility. So if it's a collective responsibility, you, the tenant, has a responsibility to make sure the law works. The landlord has a responsibility, and we as referees also have a responsibility. So if we make it an offense for you, the tenant, to pay more than 1 year, when you are paying 2 years, or landlord is demanding at the blind side of all of us, demanding 2 years, then it will be done on you that when I pay the 2 years, I'm also committing an offense. So the tenant will be very conscious.
My issue is that you don't have all-round visibility.
Exactly.
Landlords also, I don't know whether the bill is considering that the fact that the moment you think of converting your apartment or your residential property into a commercial property, you must register it.
Yes.
By so doing, there's visibility so that